Role of prosecutors in criminal justice administration. Public prosecutors play a very crucial role in most of the criminal justice systems. They are the persons entrusted with the duty of representing the prosecution side in criminal trials. The office of the public prosecutor represents the collective will of the society. It is also a repository of public power to initiate and withdraw prosecution. The reason for creation of a system of public prosecution to represent the interest of the society are twofold. Firstly, to represent the collective interest of the society to render justice in a criminal matter by punishing the offender, and secondly, to protect the interest of the individual accused by avoiding vexatious litigations. The public prosecutors are officers of the court and are regarded as independent and impartial. At the same time, they represent the state in a criminal trial. Thus, the position and role of public prosecutors has been subjected to much discussion and judicial discourse. This module will introduce you to the existing system of public prosecution in India and the role of public prosecutors in a criminal trial. After reading this module, you should be able to understand the organization of the system of public prosecution in India, understand the nature of the office of the public prosecutor and his role in the administration of criminal justice, and identify and analyze the areas of concern affecting the effective functioning of the system of prosecution. Now, we will look into the legal framework of public prosecution system in India. Public prosecutor is defined as any person appointed under section 24 and includes any person acting under the directions of public prosecutor. This is the definition given under section 2 clause U of the Code of Criminal Procedure 1973. It is a vital office as far as the administration of criminal justice is concerned. The fact that the Code of Criminal Procedure allows the public prosecutors to appear and plead in any court without any written authority conveys the importance of such offices in the administration of criminal justice. More importantly, it is provided that if a pleader is engaged by a private person in case where the public prosecutors appear, the pleader appointed by the private party has to act under the directions of the public prosecutor. This is the mandate of section 301 of CRPC. Now, chapter 2 of the Code of Criminal Procedure, titled Constitution of Criminal Courts and Offices, contain 3 provisions that talk about public prosecutors. Central or state government shall appoint public prosecutors or additional public prosecutors at the High Court to represent them in any prosecution, appeal, or other proceeding. This is the first section 24 subsection 1, which talks about appointment of public prosecutors or additional public prosecutors at the level of High Court, where the appointment are made by the central or state government after consultation with the High Court concerned. Now, the qualification, with respect to the qualification of public prosecutors and additional public prosecutors appointed at the level of High Court, the CRPC mandates that he or she shall be a person having a practice of at least 7 years or more. An advocate in practice for 7 years or more can be appointed by the state or central government as a public prosecutor or additional public prosecutor at the level of High Court. The provision also authorizes the appointment of public prosecutors or additional public prosecutors for the district to represent the state. They shall be appointed from a panel of advocates prepared by the district judge in consultation with the sessions judge. This is provided under section 24, subsection 3 and subsection 4 of CRPC. To be appointed public prosecutors at the level of district, the person must have a practice of 7 years or more. He must be an advocate in practice for 7 years or more. Section 24, subsection 6 authorizes the central government or the state government to appoint special public prosecutors for dealing with a particular case or a particular class of cases. It is mandatory for such person to have at least 10 years of active practice. Section 25 says that assistant public prosecutors can be appointed by the state government in the court of magistrates. The section also provides that if for the purpose of any case the assistant public prosecutor is not available, the district magistrate may appoint any other person to act as public prosecutor. This is at the level of the courts of magistrate. Though the general rule is that no police officer can be appointed as a public prosecutor, but when a police officer is appointed as a public prosecutor under section 25, there are two conditions to be fulfilled. First, that the particular police officer to be appointed as a public prosecutor has not taken part in the investigation of the particular case, and secondly, he is not a person who is below the rank of inspector. Now, if you look at the module and the PPT, there is a chart which is given, there is a table which is given, which gives you a fair idea about the system of public prosecution that exists at various levels. The first column dealing with the designation, second column dealing with qualification, and thirdly it talks about who are the appointing authority. The first entry is that the public prosecutor or additional public prosecutor at the level of High Court, the qualification being that he must be an advocate in practice for 7 years or more, and the appointing authority is central or state government as the case may be, and the appointment shall be made in consultation with the High Court. And the entry 2, the second level, is public prosecutors or additional public prosecutors for the district or the court of sessions. The same qualification, advocate in practice for 7 years or more, and he must be appointed from a panel. The panel must be prepared by the district magistrate in consultation with the sessions judge, or if there is a regular cadre, from that regular cadre. Thirdly, special public prosecutors must be advocates who are in practice for 10 years or more. Appointment must be made by the central or state government for a particular case or a class of cases. And lastly, assistant public prosecutors, they act in the courts of magistrate. Any person can be appointed other than a police officer. A police officer may also be appointed as an APP provided he has not taken part in the investigation and he is not below the rank of an inspector, and the appointment is usually be made by the state government. Now, a significant development in the area of appointment of public prosecutors was introduced by the Code of Criminal Procedure Amendment Act 2005. The amendment empowers the state government to establish a hierarchical structure for prosecution. The state can establish a Directorate of Prosecution under the Department of Home Affairs, and it shall be headed by a Director of Prosecution, and under him there will be Deputy Directors. This is introduced by the section 25A, which was inserted under the by the Amendment Act of 2005. And Section 25 capital A subsection 7 authorizes the state government to lay down the powers and functions of these officers. So this is with respect to the hierarchical structure that exists in India with respect to the public prosecution. Now we'll go into the characteristic and how these characteristics of the public prosecution system in India influences the criminal justice process either positively or negatively. The first question to be asked is, what is the true nature of the office of the public prosecutor? Is he an advocate of the state? Therefore, is he acting as a advocate of the state? So, is the state his client? Or is he an employee of the government? Or is his relation with the government purely contractual? Now, we will address this issue of the nature of the public prosecutor, the office of the public prosecutor, under two heads or asking two questions. First is the public prosecutor a part of the executive or is he a part of the judiciary? Secondly, is his office, the office of the public prosecutor, a public office? We'll go to the first question. Is the public prosecutor a part of the executive or the judiciary? Why is it said to be a part of the executive? Because he represents the state and acts in cooperation with the investigating agency. He acts on behalf of the state and he acts in aid or in cooperation with the police. He is said to be a part of the judiciary because it is said that he has to be impartial, independent of the government, and he has to aid the judiciary, aid the court in finding the truth. Is he an officer of the court? Professor K. Chandrasekharan Pillai, a learned author of criminal law, is pertinent here. He says, I quote, "It seems that the office of the public prosecutor belongs to the executive. However, it is strongly felt that it is in fact not purely executive. It partakes judicial character and as such assumes a lot of importance in a democracy. The very establishment of this office presupposes the understanding that one cannot afford to permit private prosecutions as it may result in utter chaos in the present political setup." Unquote. The public prosecutor was treated to be a part of the executive earlier, and the need to separate it from the government, from the executive, and give it an impartial, independent existence was felt in gradually. And accordingly, if you look at the Law Commission reports, specifically the 14th report of the Law Commission of India says, I quote, "It is obvious that by the very fact of that being members of the police force and the nature of duties they have to discharge, like bringing the case to the court, it is not possible for them to exhibit that degree of detachment which is necessary in a prosecutor. It is to be remembered that their promotion in the department depends upon the number of convictions they are able to obtain as prosecuting officers. We therefore suggest that as a first step towards improvement, the prosecuting agency should be completely separated from the police department. These recommendations of the Law Commission were accepted by the central government and accordingly Amendment Act of 1973, which enacted the new CRPC of 1973, the provisions and necessary changes were made in section 24 and 25 of CRPC. Nature of the functions of the public prosecutor perform has elements of executive function. It cannot be treated so. That is what has emerged over the years. He represents the state, but his role in the court is not that of an ordinary lawyer representing his client. In this regard, the observations made by the High Court of Kerala in Babu vs. State of Kerala is worth mentioning. It's a 1984 decision. In this case, the court observed, I quote, public prosecutors are really ministers of justice whose job is none other than assisting the state in the administration of justice. They are not representatives of any party. Their job is to assist the court by placing before the court all relevant aspects of the case. They are not there to use the innocents to go to gallows. They are not there to see the culprits escape conviction. But the pleader engaged by a private party who is a de facto complainant cannot be expected to be so impartial. Not only that, it will be his endeavor to get a conviction even if a conviction may not be possible. Unquote. There are instances where the courts have held appointment of a police officer in charge of a prosecuting agency to be against the spirit of section 24 and 25. Under the scheme of the court, investigation is done by the executive, that is the police, and supervision of investigation is the duty of the judiciary, that is the magistrate. Public prosecutor is an officer of the court who aids the court in the administration of justice by helping it to find the truth. So that is the spirit of section 24 and 25. In short, it may be said that irrespective of the judicial or executive nature of the office of the public prosecutor, he has to act impartially and with fairness. Now, coming to the second question with respect to the nature of the office of the public prosecutor, is it a public office? What is his relation to the government? He is not a part of the executive, but then what is the kind of relationship he shares with the government? Is a public prosecutor a public servant, or is he just an advocate whose client happens to be the state? In other words, is the relation between the government and the public prosecutor purely contractual, or does it involve some public element so as to claim the office to be a public office? This issue was addressed by the Supreme Court in Kumari Srilekha Vidyarthi vs. State of UP and others, a 1991 decision. In this decision, the government councils of the state challenged the state action of terminating their services before the expiry of the term without assigning any reason as arbitrary. They contended that the relationship of the government council with the government is not merely one of client and counsel, as in the case of a private client, but one of status in the nature of a public employment or appointment to a public office. Having regard to the statutory provisions concerning the appointment of public prosecutors and their role in withdrawal from prosecution under section 321 of the Code of Criminal Procedure, we'll come to that later, the court held that the office of the public prosecutor is a public office and his relationship with the government is not the same as that of an ordinary advocate representing his client. Their reasoning was primarily revolving around section 321 of CRPC, which provides for withdrawal from prosecution and places the public prosecutor as the main person, as the main decision maker. In this context, the court made the following observations in Kumari Srilekha Vidyarthi's case. I quote, "This power of the public prosecutor in charge of the case, that is a power under section 321, is derived from statute, and the guiding consideration for it must be the interest of administration of justice. There can be no doubt that this function of the public prosecutor relates to a public purpose, entrusting him with the responsibility of so acting only in the interest of administration of justice. In the case of public prosecutors, this additional public element flowing from statutory provisions in the Code of Criminal Procedure undoubtedly invests the public prosecutors with the attribute of holder of public office, which cannot be whittled down by the assertion that their engagement is purely professional between a client and his lawyer with no public element attached to it. Unquote. So, this is the nature of the office of the public prosecutor has emerged over the years through the statutory provisions and the case laws. They are neither part of the executive, they are officers of the, they are not part of the executive, they are officers of the court. They hold a public office. Their relation with the government is not that of an ordinary lawyer or an advocate representing the client. We'll talk about the second attribute of the public prosecutor, which is a bit problematic in the scenario, in the criminal justice scenario of India. That is the independence and impartiality of the office of the public prosecutor. Public prosecutors must be impartial and fair. That is what we were discussing in the earlier uh, points. His role is not limited to that of an advocate championing the cause of his client. He is not to secure conviction by all costs, say, for example, by hiding evidences or information favoring the accused. He is to aid the court in its quest to find the truth. But what are the parameters to assess this impartiality? How do you know that a particular public prosecutor is being impartial? How is fairness of his actions to be measured? There have been numerous instances before the court where such a public office was alleged to be misused either by the incumbents of the office or by their political superiors. Two issues that need to be addressed in this context, the context of independence and impartiality of the office of the public prosecutor, are first is the political nature of their appointments. Secondly, the government's interference in withdrawal from prosecution. Political interference. A major area of concern when we talk about impartiality and independence of the office of the public prosecutor is the reality of such public offices being filled by candidates who are committed to their political heads or who are committed to a particular political party. It is often the practice that the offices of the public prosecutors and government pleaders changing its incumbents with a change in governments. The judiciary has been quite meticulous in its approach, preventing politically motivated appointments and keeping a check on partisan decision being taken by occupants of such offices. Professor Pillai makes the following observation in this regard. I quote, "Today, the appointment to the office of the public prosecutor is made on the basis of political affiliation of the persons concerned. The difficulties arising out of such appointments came to be examined by the Supreme Court in Sri Lekha Vidyarthi versus State of UP. The Supreme Court deprecated this trend and declared that appointment to such vital offices should not be allowed to be made by spoils system by the political parties. But even today, the state government distribute the offices among the sympathizers of political parties in power. And even after assuming office, many of the incumbents still feel that they are to look after the interest of the ruling parties." Unquote. The case of Sunil Kumar Pal versus Rota Sheikh provides a very candid example as to how political influences can lead to utter abuse of the office of the public prosecutor. A 1984 decision of the Supreme Court. It was a case of murder. Due to persistent demand of the deceased brother, the proceedings began. The public prosecutor was given only a day, to prepare his case, and therefore he returned his brief. After that, A junior of the said public prosecutor was appointed as the special public prosecutor, and the public prosecutor concerned was representing 9 accused. Witnesses were intimidated, many of them turned hostile, and many did not even appear. The High Court, once the decision was rendered, the High Court did not even grant a leave to appeal to the apex court against the acquittal. Setting aside the acquittal in this case, the apex court came down heavily on the way justice was administered by the lower courts. It made the following observations. I quote: there can be little doubt that the trial culminating in the acquittal of respondent numbers 1 to 9 was appallingly unfair so far as the prosecution is concerned, and was heavily lauded in favor of respondents number 1 to 9. It is difficult to understand how consistently with ethics of the legal profession and fair play in the administration of justice, the public prosecutor of Nadia could appear on behalf of respondent numbers 1 to 9. The appearance of public prosecutor Nadia on behalf of the defense does lend support to the allegation of the appellant that respondent numbers 1 to 9 were supported by the Communist Party of India, which was at the material time the ruling party of the state of West Bengal. And this would naturally give rise to apprehension in the minds of the witnesses that in giving evidence against respondent numbers 1 to 9, they would be not only incurring the displeasure of the government but would also be fighting against it. Moreover, it cannot be disputed that when the trial was going on and the witnesses were giving evidence, there were a large number of supporters of the Communist Party who were allowed to assemble in the court compound and who created a hostile atmosphere by shouting against the prosecution and in favor of the accused. Though the appellant and the complainant, as also the witnesses, were intimidated, no steps were taken for according protection to them so that they may be able to give evidence truly and fearlessly in proper atmosphere consistent with the sanctity of the court. It is significant to note that quite a few witnesses turned hostile, and that obviously must have been due to the fact that they apprehended danger to their life at the hands of respondent numbers 1 to 9 and their supporters. It is also regrettable that, though at the time when the trial commenced on 22nd May 1978, Sri S.N. Ganguly, who was appointed special public prosecutor to conduct the prosecution, asked for an adjournment of the trial in order to enable him to prepare the case, particularly since he was appointed on 20th May 1978. The trial was adjourned only for a day, with the result that S.N. Ganguly had to return the brief. Then, late in the evening of 22nd May 1978, Sri S.S. Sen, additional public prosecutor, was asked to conduct the prosecution, and he had to begin the case on the very next morning, that is 23rd May 1971, without practically any time for effective preparation. We have no doubt that under these circumstances, the trial was heavily loaded in favor of the respondent numbers 1 to 9. The trial must, in the circumstances, be held to be vitiated, and acquittal of respondent numbers 1 to 9 as a result of such trial must be set aside. It is imperative that in order that people may lose faith in the administration of criminal justice, no one should be allowed to subvert the legal process. No citizen should go away with the feeling that he could not get justice from the court because the other side was socially, economically, or politically powerful and could manipulate the legal process. That would be subversive to the rule of law. Unquote. So this is what the Supreme Court observed with respect to the need for impartiality and independence, and need to avoid politically motivated appointments and politically motivated actions of the public prosecutors. Now, second, prosecutors and withdrawal from prosecution. Now, prosecutors play a very important role in the criminal proceedings. For example, if you look at chapter 18 which deals with the trial before a court of session, it opens with the provision that every trial before a court of session, prosecution shall be conducted by a public prosecutor. Further, the prosecution has to open the case by describing the charges and the evidences against the accused. The evidence the public prosecutor mentions in the opening statement are the one which are prepared by the magistrate, sent by the magistrate while committing the case to the court of sessions. Now, an important aspect of the public prosecutor's impartiality is tested with respect to section 321. He has a very important role in a court of sessions. When the trial begins, he has to open the case, he has to read out the charges against the accused. A more important role of public prosecutor can be seen under section 321 with respect to withdrawal from prosecution. The public prosecutor plays a vital role in cases where withdrawal is sought on behalf of the state. According to section 321 of the code, I quote, the public prosecutor or assistant public prosecutor in charge of the case may, with the consent of the court, at any time before the judgment is pronounced, withdraw from prosecution of any person, either generally or in respect of any one or more of the offences for which he is tried. So this is the prerogative of the public prosecutor or the assistant public prosecutor who is in charge of the case. It has to get the consent of the court, and it can be done at any time before the judgment is pronounced. They can withdraw from prosecution either generally with respect to a particular case or with respect to particular charges in relation to a case. This role of the public prosecutor has been a testing ground for the notions of independence and impartiality associated with his office. The reality of such decisions, which are to be made independently of external influences, being influenced or manipulated by political heads of the state, has resulted in many situations where judicial interference became necessary. It has now been categorically laid down by various judgments that the decision to withdraw from prosecution is the prerogative of the prosecutor as the holder of public office, and the court shall give consent to such a decision only if it is satisfied that the decision is not influenced by the interest of the political government. The case in point is Shionandan Paswan versus State of Bihar, a 1987 Supreme Court decision where the apex court held that the role of the court in granting permission for withdrawal of prosecution is limited to seeing that the decision is made by the public prosecutor independently and having regard to the interest of public policy and justice. The public prosecutor's decision to apply for withdrawal is not limited to paucity of evidence. Once the court is satisfied that the application is made in good faith, in the interest of justice and public policy, and not to thwart or stifle the process of law, the court may grant permission. In other words, the role of the court in this regard is not adjudicatory, but only supervisory. The court need not go into the merits or the reasons for withdrawal. Merits of the reasons for withdrawal. It has to just satisfy itself that the decision is made independently and good faith by the public prosecutor. The same has been the approach of the court in a number of decisions. For example, R.K. Jain versus State 1980, Muhammad Mumta versus Nandini Sadpati 1987, all Supreme Court decisions. So what we can conclude from all these decisions dealing with withdrawal from prosecution are, we can make some points here. Firstly, decision to withdraw prosecution is a prerogative of the public prosecutor. Secondly, Decision to withdraw prosecution under Section 321 of the Code may be exercised by the public prosecutor any time before the judgment is pronounced. Thirdly, consent of the court is necessary for the public prosecutor to withdraw from a case. The role of the court in this regard is not adjudicatory but supervisory. Fourth, if the decision of the public prosecutor is independent and in the interest of justice, the court has to give permission. Fifthly, the decision to withdraw prosecution may be due to paucity of evidence, but there may be other reasons also. Finally, as long as the decision of the public prosecutor is made in good faith and free from all external influences, especially like governmental pressure, the courts shall not interfere. So, these are the two basic concerns when we talk about the independent and impartiality of the office of the public prosecutor, political appointments and political interference in their working, and secondly, the role of the prosecutor in the withdrawal from prosecution and how much impartiality and independence can they have. Now, the last element which need to be taken care of in this regard is the duty of the public prosecutor, or the role of an examination of the role of the public prosecutor will not be complete unless we talk about the duties of public prosecutors also. The most important duty of the public prosecutor is the duty not to suppress any material fact or evidence relevant to the case. As mentioned earlier, the public prosecutor is not just an advocate representing the interest of his client. Therefore, he need not produce a conviction by hook or crook. The object of a criminal trial is to find out the truth and determine the guilt or innocence of the accused. The duty of the prosecutor in such a trial is not merely to secure conviction at all costs, but to place before the court whatever evidence is possessed by the prosecution, whether it be in favor or against the accused, and to leave the court to decide upon all such evidence, whether the accused was or was not guilty of the offense alleged. The attitude expected from the public prosecutor is made clear by the Law Commission's 14th report. It says, I quote, a public prosecutor must be personally indifferent to the result of the case. His duty should consist only in placing all the available evidence, irrespective of the fact that whether it goes against the accused or helps him before the court, in order to aid the court in discovering the truth. It would thus be seen that in the machinery of justice, a public prosecutor has to play a very responsible role. The impartiality of his conduct is as vital as the impartiality of the court itself. Unquote. In Darya Singh versus State of Punjab, 1965 Supreme Court, the apex court held that the public prosecutor must never allow the device of keeping back from the court's eye witnesses only because their evidence is likely to go against a prosecution case. In other words, he shall not pick and choose witnesses and evidences. So this is with respect to the duty of the public prosecutors. Now, as a summary to the whole module, we can say that public prosecutors play a very important, vital role in the administration of criminal justice. It is an office created by the statute. The public officer represents the state in criminal prosecutions. However, he is not an advocate of the state. He is the holder of a public office and has to discharge his functions impartially and independently. They are not to suppress material facts, evidences, or witnesses, even if it is not in the favor of the case. In other words, he is not to secure a conviction by any means. His duty is to aid the court in finding the truth. Politically motivated appointments and interference by political heads in the decisions concerning prosecutions are challenges to the independent working of the office, which has been dealt quite seriously by the judiciary. Thank you.